To deny people their human rights is to challenge their very humanity. These are the words of Nelson Mandela, who was an anti apartheid revolutionary, first black president of South Africa, and famously known as the champion of human rights. Very good afternoon and pranam to everyone. I, Dolly Singh, Assistant Professor, Faculty of Law, Banaras University, would like to extend a very warm welcome to Professor Rakesh Bhatnagar, Vice Chancellor, Banaras University, Professor R.P. Rai, Head and Dean, Faculty of Law, Banaras University, all my respected learned colleagues, speakers from all corners of the world who have agreed to devote their time to share their opinions, and most importantly, audience for the day who have joined us through this virtual platform for the international webinar on the theme Human Rights Derogation amidst COVID-19, a comparative discourse on issues and challenges. Well, before proceeding further, following our holy traditions, I would request everyone to please join us in the ceremonial recitation of the Kulgi. Please, thank you.
है विश्वकर्मा का कार्य रचे यहीं पर ये ब्रह्म विद्या की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी।
ये मुक्ति पद को दिलाने वाले, सुधर्म पथ पर चलाने वाले, यहीं फले फूले बुद्ध शंकर।
ये राज ऋषियों की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी। रम्य धाराएं वरुणासी, नहाए जिनमें कबीर तुलसी। भला हो कविता का क्यों न आकर ये वाग विद्या की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी।
विविध कलार्थ शास्त्र गायन, गणित खनिज औषधि रसायन, प्रतीचि प्राची का मेल सुंदर।
ये विश्वविद्या की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी। हिमालय जी की देशभक्ति, ये उनका साहस, ये उनकी शक्ति प्रकट हुई है नवीन होकर ये कर्मवीरों की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी। मधुर मनोहर अतीव सुंदर ये सर्व विद्या की राजधानी, राजधानी।
Whenever we human beings try to challenge the existence of the God or try to prove ourselves a bit superior, nature bounces back in the form of pandemic disease that forces us either to surrender or to lock ourselves in the homes. I believe the current outbreak of COVID-19 as the same warning from the nature that has caged the entire world. The coronavirus outbreak came to the light in the month of December 2019 when China informed World Health Organization about a cluster of cases of pneumonia from an unknown cause in Wuhan city in Hubei province. Subsequently, the disease spreaded to more provinces of the China and to rest of the world as well. The World Health Organization declared it as a pandemic that has turned the entire world upside down. With these words, I invite Professor R.K. Patel, convener, Seminar Committee, Faculty of Law, Banaras Hindu University, to please provide us with the opening remarks. Please, sir.
Thank you, Ms. Dolly, for giving this opportunity to me. Honorable Vice Chancellor Professor Rakesh Bhatnagar, respected Dean Faculty of Law Professor R.P. Rai, distinguished speakers of the today's webinar, esteemed colleagues, valuable participant, and dear student. A warm welcome and very good afternoon to all of you. Today, I am very happy and feels privileged to present this international webinar before you on behalf of the Seminar Committee of Law School, Banaras University, which is always devoted to organize lectures, deliberation, talks, and the seminar on contemporary topics of the law as well as interdisciplinary subjects. The topic which we have chosen today for the discussion is human rights derogation amidst COVID-19, a comparative discourse in issues and challenges. Considering the current situation of the entire world, it is needless to say that this topic is too important in the present day context. In our last webinar, we have tried to focus on the health issue during pandemic period, and today topic will take the issues in perspective of human rights. As we know that human rights are inherent rights and non-discriminatory rights provided to all human beings regardless of their gender, nationality, residence, sex, color, and other categorization. There are a variety of human rights including civil rights, political rights, economic rights, social rights, cultural rights, and collective rights too. The things which are important for the human right is that all the rights are available to human being, but it is not given by human being or even by the government to them. Therefore, every person has inherited it by the birth. As it is clear from the language of Indian Constitution related with the fundamental rights that states shall not deny, or you can take the another example of no person shall be deprived. It means the rights conferred under part 3rd of the Indian Constitution particularly, it is not provided by the government or by the state but by a supernatural power. This is a reason why the state is not empowered to snatch these basic rights or human rights even in an emergency like situation. Nowadays, the entire world is under a pandemic attack which is killing the masses, disturbing the life of the society, which is willingly or unwillingly also resulting into huge violation of the human right. To discuss these issues, we have created a galaxy of intellectuals from India and abroad, which includes medical professionals, law professors, and the legal practitioners too. I hope this webinar will be beneficial to the researcher, to the academicians, and as well as the citizens in general. With these words, I again welcome you all and request Ms. Dolly to continue the proceeding. Thank you.
Thank you, sir. You've precisely stated the inconceivable stage we all are passing through. There's hardly any aspect of our life that has remained untouched by this current pandemic, and due to its incurable nature for now, nationwide lockdowns have been imposed throughout the world. Governance system at all levels, whether global, national, or local, are experiencing a stress as a fallout of this pandemic. At the same time, breakdown of systems like healthcare, logistics, finance, administration have created complexities in the management that have led to the intense dilution of human rights. Human rights, the rights to which we are inherently entitled, the rights which are non negotiable, the rights which should never ever be compromised with. With these words, I would request Professor Rakesh Bhatnagar, Honorable Vice Chancellor of Banaras Hindu University, to please grace the occasion with his insights. Please, sir, I request you. Thank you.
I am happy to extend cordial welcome to the distinguished guests, speakers, and all the participants who have joined through virtual platform in this international webinar organized by Faculty of Law, Banaras Hindu University. I extend very warm welcome to the distinguished speakers, including one from University of Hampshire, USA, and the second one from University of Turku, Finland, who have agreed to be part of this webinar and share their valuable thoughts with us on human rights issues in COVID-19. COVID-19 times. The WHO has declared the outbreak of COVID-19 as pandemic on March 11, 2020. And since then, nations have started taking hard decisions of unconventional nature in response to COVID-19. We all know that coronavirus COVID-19 has spread to almost all the corners of the globe. Respective governments are under an obligation to undertake effective actions to protect their citizens from this pandemic and their public health crisis. Thus, national governments have taken the range of measures to restrict its rapid spread. These measures include mandatory self-quarantining, limiting the public gatherings, and reducing the business hours to non-essential commodities and items. These steps are taken for safeguarding the health of community at large, as governments are under an obligation to take care of the society. When it comes to practice and execution, the corresponding steps taken by the states to safeguard community life and health somewhere also conflict with individual rights. Governments have an inherent obligation to protect and safeguard basic fundamental rights of individuals and citizens that are also popularly referred as basic human rights. This hardly needs much explanation here that various international human rights instruments, including the Universal Declaration of Human Rights, which is generally agreed to the foundation of international human rights law, and other globally binding international human rights treaties are of great help in our quest to address injustices in times of conflict, during the period of pandemic, or when societies suffer repression. According to the new UN report on human rights released by Secretary General, the rights to life and duty to protect life, right to health and access to care, and freedom of movement are frontline responsibilities of the state in the current pandemic. In reference to the objectives set by Universal Declaration on Human Rights, embracing human rights as an integral part of our public health system, it may be stated that they will not only provide ethical guidance during these difficult times, but set the foundation for how the humanity responded to public health crisis as it goes forward. It needs to be emphasized that the states, while adopting stringent measures, must be mindful of the fact that certain human rights are also so basic that they are treated as non-derogable. When it comes to use of special measures while handling COVID-19 pandemic, these measures must also be used to legitimate public goods and not used as the basis of denying other human rights or take any other steps that are not necessary to address the health situation. Observing things practically, the scenario turns out to be a matter of concern calling our attention. Handling the health crisis often results in human rights crisis. The victims are mainly marginalized section of the society, prisoners, religious and ethnic minorities, people with disabilities, women, aged groups, migrants or guest workers, children and refugees. It seems COVID-19 is not only a health crisis but also posed challenge to the existing norms of human rights. It is affecting all forms of human rights, both in their uniqueness and their interdependent characteristics. Maintaining the pre-COVID 19 standards of human rights is a test of the societies, of governments, of communities, and of individuals. I hope that this international webinar set the platform to focus on human rights that gets affected in the government's attempts to restrict the spread of COVID-19 pandemic. As part of deliberation, this webinar also suggests the alternatives which the government can adopt while handling the health crisis. With these words, I once again welcome you all in this international webinar. Thank you.
Thank you, sir. Thank you so much for your words. Well, moving further, states have obligation to protect, promote, and give effect to all the human rights to all groups under their jurisdiction, and first and foremost take care of those who are very much vulnerable, like children, people with disabilities, older people, refugees, migrants, etc. States must also refrain from violating the human rights of groups in other states' jurisdiction. In addition, the states which are having ample resources must act in solidarity by guaranteeing the human rights enjoyment to their population as well as the population of the state which are lacking in resources. But nothing like that is seen happening, and accordingly, we all are watching, we all are witnessing violations, massive violations of human rights all over the continent. And to discuss this human rights violations comprehensively and to bring out some remedy, we all are assembled here over this virtual platform. Well, before moving in depth towards the discussion, I would request Professor R.P. Rai, Head and Dean, Faculty of Law, Banaras Hindu University, to please formally welcome all the speakers who have agreed to come over the platform to share their opinions. Please, sir, we request you. Thank you.
Good afternoon to one and all. It is a matter of honor for me to welcome chief guest for today's webinar, Honorable Vice Chancellor, Banaras Hindu University, Professor Rakesh Bhatnagarji, distinguished speakers, learned colleagues, dear students, and all those viewing this webinar through virtual platform. I hope you all are safe at your places and wish that we soon overcome the crisis caused by COVID 19. This is the first international webinar organized by Law School, Banaras Hindu University on the theme of human rights, derogation amidst COVID 19. I expressly my thanks to our Vice Chancellor for always sparing time to all our academic events. For today's webinar, we have speakers Professor Albert E. Secher from University of New Hampshire, United States, Dr. Sergey V. Nestinov from University of Turku, Finland, Sri Amit Anand Tiwari, Advocate Supreme Court of India, and Sri Seetal Sethia, Assistant Professor, University of Mumbai. It is a matter of privilege for us that even during this phase of health crisis caused by COVID 19, they have consented to share their thoughts as a speaker for this webinar. I welcome you all, friends. The topic of webinar, Human Rights Derogation amidst COVID 19, is to initiate a discourse on the nature of crisis faced by people in India as well as abroad because of COVID-19 pandemic. This comparative discourse through virtual platform would bring before us the impact on human rights because of medical and legal approaches adopted by respective governments of India, United States, and Europe. While handling this challenge of unprecedented scale, like other nations in the world, India is also facing crisis period due to chronic nature of pandemic. At its core is health system where the citizens have put their hopes after experiencing that private sector healthcare system is driven by rise and fall in profit and loss graph. Further reflecting on the private sector healthcare system, it seems they are working with minimal priority for social welfare. As the private sector seems withdrawn from frontline position for handling these challenges, state as a barrier of rights of its citizen need to widen ambit of responsibility towards its citizens. Further adding to it, during this pandemic, government's approach is contrary to what is defined in terms of right, but it is because of nations are left with no choice, rather to adopt extraordinary measures. The extensive lockdown enforced by the government has led to the slow transmission of virus. However, at the cost of curtailment of freedoms, such as restricting the freedom of movement of people, guest workers, and guest workers became the worst sufferers and in process of constraining other kinds of basic liberties. Our societies faced repercussions because of such measures. Such effect could be seen in many other places across the world where measures similar nature were adopted by the respected governments. The inherent features of fundamental right mentioned in our constitution rest on the normative foundation of human rights. During this crucial period, where hopes from the respective governments are high, whether it is India, United States, or Europe, the required government measures in response to it need to be based on for human rights. Such an approach shall expeditiously result in effective and rather far-sighted outcome, thus proving the governments of respective states to be wiser in overcoming the pandemic and its effects, observing the crisis and its impact from the prism of human rights. Today's discourse focuses on how citizens are getting affected because of pandemic and mainly the most vulnerable among us. State responses that are shaping in keeping mind the fundamentals values based on human rights incline us to specify who is suffering the most or where is the urgency of requirement. Such an approach can prepare us with a policy measure having more equitable and sustainable solutions. Before concluding, I would like to thank the health care workers, also termed as Corona warriors, who are always on front line. I strongly argue that their rights need serious consideration, both from the side of the government and from the side of the people. In the light of this background, the premise that there is human rights derogation amidst COVID-19 is set for today's comparative discourse on issues and challenges. With these words, I welcome Honorable Vice Chancellor, learned speakers, our colleagues, students, and all viewers participating in this international webinar. Thanking you. Jai Hind.
Thank you, sir. Thank you so much. We are always delighted to hear you, and thank you for always being encouraging us. Moving further, as discussed, while the fight with the current pandemic is demanding intense measures by the government, it is also exposing the inequalities in impact and human rights protection all across the world. The pressures arising and the difficulties in responding run the risk of undermining entitlements, reducing risks, and removing safeguards. The starkest expression of these lies in the inequality of access to protection from abuse and neglect, access to the treatment to sustain life, and devastating death rates in our society, and much, much more. To elaborate on the theme of the webinar, I would invite Dr. Gurvinder Singh, Assistant Professor, Faculty of Law, Banaras, Hindu University. Please, sir, I invite you. Thank you.
Honorable Vice Chancellor Professor Rakesh Bhatnagar ji, respected Head and Dean Professor R.P. Rai ji, distinguished speakers, esteemed faculty members, colleagues, and my dear friends. Good afternoon to you all. I welcome all those who have shown interest and are participating in this international webinar. I am very much thankful to the speakers who have kindly agreed to give time to us and for sharing their thoughts on this relevant issue. As we all know, the governments all across have taken strict measures to restrict the spread of COVID-19 pandemic. These measures indeed gives extra power to the state, and thereby it also creates risk that state may encroach upon the rights of citizens and individuals. Traditionally, we relate the concept of human rights with the relationship between individuals or citizens and the territorial state. In this pandemic situation, we probably need to think out of the box as new set of responsibilities seem to emerge. We can divide this in three headings. Firstly, whether international law allows deviation from human rights. Secondly, how the role of the state can be defined in the pandemic period so that there is minimum infringement of the rights of the citizens or the individuals. Thirdly, the role played by the private sector in safeguarding the basic human values that fall within the domain of human rights. I take the first point in brief. From international law perspective, at its very outset and at the core level, international law recognizes and its various provisions enables for the maintenance of human rights. In the case of war or any such emergency-like situation, a minimum standard is expected to be maintained by the states, parties to the various international law treaties and conventions. These minimum set of values are also termed as inalienable set of human rights. Since the COVID-19 is a special or emergency-like situation, the question arises whether international law permits any deviation from the established practices of the following human rights. The answer is yes, with regard to this human rights treaties such as United Nations treaties on international covenant on civil and political rights and some of the regional conventions gives to the state far-reaching option to derogate from some of its obligations during the situation of grave crisis. But we must be clear that human rights from international law perspective can be divided as derogable and non-derogable rights. To make things more clear, I would like to quote Article 4, Clause 1 of the International Covenant on Civil and Political Rights. The clause states that in the time of public emergency, which threatens the life of nation and the existence of which is officially proclaimed, the state parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with their obligations under international law and do not involve discrimination solely on the ground of race, religion, sex, color, language, or social origin. The other two similar such treaties are American Convention on Human Rights, Section 27 of this convention, European Convention of Human Rights, Section 15 of this convention. Taking the second point, that is how the role of state can be defined and its functioning compared between normal circumstances and the emergency situations like COVID-19. Many states have resorted to domestic emergency powers either nationally or on regional or on local basis. What makes these domestic emergency measures matters of serious concern is their inherent characteristics, as these powers typically entail rules by decree, which means executive body assuming the rule making power that in normal circumstances is with the parliament. Needful to note here that there is a difference between rule of law and rule by decree. Such emergency power also carry grave risk of being abused, often for the political purposes such as curtailing dissent, dissolving elected governments, postponing elections. The political developments in Madhya Pradesh is one such glaring example of the abuse of power. These happenings and political maneuvering makes the legal discussion forum no more confined to conventional way of judging the role of state. It demands us to analyze and set the premise for appraisal as to how the governments are functioning in these conditions. If these issues are not debated from human rights perspective, then it could be that after COVID-19, our society retreats from social and individual freedoms and also from the new horizons of liberty which every generation wants to reach. Further to add here that society may resurface as state with weaker judiciary, censored and biased media, single party autarky, and provinces at the mercy of center when it comes to allocation of taxes. Now in the last, coming to the third issue, that is role of private sector during the pandemic. Conventionally, the expectations from private sector are of different order when it comes to sustaining human rights values. Mainly such set of objectives are featured in different set of rules and bylaws, for example, labor laws, Minimum Wages Act, corporate social responsibility, and several such obligations. With the government opting for lockdowns, the entire economic activities has come to halt or has slowed down to minimum. The question arises that as the production sector is no more functional or has slowed down, then how can businesses or commercial sector provide minimum support to the workers? This indeed is not an easy choice. The existing laws does not include sufficient provisions for sharing responsibilities by the private sector during the pandemic-like crisis. The governments have introduced changes in the labor laws that ironically reduces the bargaining power of the laborers. The working hours have been increased, the wages and allowances are no more guaranteed. This directly or indirectly affect the basic liberty and freedom of choices that we all humans have in democratic society. In the light of this background, for today's discussion, we set the premise as international webinar on human rights derogation amidst COVID-19, a comparative discourse on issues and challenges. With these words, I welcome you all for today's international webinar. Thank you.
Thank you, sir. Thank you for setting the stage for deliberation. The current health crisis has not changed the situation. It has rather brought to the light the disparity between and within the countries in terms of the capacity to respond and take adequate health measures. For example, some states have imposed strict lockdowns and the wearing of masks for entire population, while others have been much less strict or maybe even at first have refused to face up the reality of the epidemic. The fact that health experts do not yet know enough about the virus goes some way to explaining these differences. But they seem more to be related to the resources. Some states believe that economy must keep going on no matter what the social utility of a given industry in an emergency situation and regardless of the risks to the workers and public health, while at the same time they are unable to provide population with the medical or food products. In addition, many countries have no healthcare networks which can be of some utility, which can be of some help to the people who are suffering with the pandemic. In this context, I would introduce our keynote speaker for the event, Professor Albert E. Scher, to share his views on implications of the current pandemic from the American perspective. Before moving further, I would like to introduce Professor Albert. Professor Albert completed his graduation from Yale University and legal education from Vermont Law School. His areas of expertise include constitutional criminal procedure, trial advocacy, evidence genetics, and legal system and human rights. With these specializations, Sir has been involved in intense research and have published remarkable works in international and national journals like Georgia Law Review, New Hampshire Bar Journal, and many other journals of international repute. Sir has made number of presentations on international and national seminars and conferences. He has been a principal investigator of 2-year grant to study genetics, police investigation, and constitutional privacy. Sir has also been a member of many litigation and advocacy projects. In addition to his excellence in the academics, Professor Albert has been discharging efficiently his responsibilities on the administrative front as well. Some of his administrative positions include Director, University of New Hampshire Law Undergraduate Program, Director, Trial Advocacy Program, Director, Online Initiatives in Intellectual Property, International Criminal Law, and Justice, and many more. Sir, we feel highly honored to have you over this platform, and we request you to please share your views of the COVID from the American perspective. Please, sir, we request you. Thank you.
Is really going to break down into three parts. First, the public health crisis from the coronavirus, the COVID-19 virus in the United States, and number one, and the dimensions of it, which are quite significant. Something like we've never seen, certainly in the last. The only thing close to this is the flu pandemic back in 1918 and 1919. So I'll talk a little bit about the dimensions of the spread of the virus. Number two, I will talk about how it has impacted human rights in the United States, particularly how government efforts or lack of efforts, both, have impacted human rights in the United States. And then I'll try and sum up by addressing what my concerns are for going forward, given this episode, assuming that eventually we will the virus will get under control, either by significant population immunity or through the prevalence of vaccines, ideally at the beginning of next year. I will talk about what I think the long-term consequences of what we've been through in terms of human rights are. So first, let me describe for you my sense of the public health crisis in the United States. At this point, in the beginning of July, there are over 2 million positive cases of COVID-19 in the United States, which is more than any other country in the world, is my current understanding. As of yesterday, towards the beginning of July, over 132,000 Americans have died from the virus, which is a remarkable number. Originally, much of the pandemic was in the cities in the Northeast, in New York, in Washington, D.C., and in some of the bigger cities, Chicago, Detroit in the Midwest. The spread of the virus in the Northeast of the United States, in New York State, in the New England states, has slowed down somewhat, a good bit, but now the virus is raging at even a stronger and higher level in many of the southern states and in California, particularly in Florida, the state of Florida, the state of Texas, the state of Arizona, and California. And it's turned into a nightmare. We are seeing somewhere over 50,000 cases a day diagnosed in the country overall, which is more than the original surge of the virus in the Northeast back in March, April, and May. So we are in the middle of the virus still. It is not, it has not diminished. It has shifted to another location. There is some concern that the virus has mutated and made itself much more transferable. There's some genetic evidence of that in Houston, Texas area. That is of concern. And there is yet to be a significant rise in the death toll from this latest surge of the virus, probably because it just started 2 to 3 weeks ago, and deaths tend to occur 2 weeks at a point somewhere first 2 weeks after the person contracts the virus, and then for those who are seriously ill, they are hospitalized, and it's at that point that we start to see the rise in a death toll. So it's anywhere from 3 to 5 weeks from the onset of a new surge that we start to see an increase in the death toll. So it's a very significant, to say the least, public health crisis. And it has been aggravated by a confusion in management of the virus. The federal government in the United States has chosen to be relatively passive in managing the virus. The president has said long ago, has been very skeptical from the beginning of the seriousness of the virus. He has then expected it to go away very quickly. He's then decided that it is not very serious, it's not spread very widely. And finally, when he recognized that it had become a more serious problem belatedly, he has said that it's up to the states to manage it. And the federal government will try and offer support to the states, but it's up to the states to manage it. And that has led to a lack of federal support nationally for the management of the virus, which has aggravated the concerns about its spread and has aggravated its spread for that matter. There's been difficulty with access to testing. There's been difficulty with access to protective equipment in hospitals. There has been, even very recently, the state of Arizona had asked the federal government for help in testing and more testing capability in order to do what is known as contact tracing, and I'll talk about that in a few minutes. And the federal government declined to offer that assistance. So unfortunately, the most significant impact, the significant role of the federal government has been diminished. They have not played a role that traditionally they have played in managing epidemics and pandemics. There were plans in place by the George W. Bush administration and the Barack Obama administration. There are very well developed plans in place for the management of a pandemic. And the Trump administration threw those plans out and defunded and disbanded the unit that was in charge of that plan. So it has been a very difficult time in the United States in trusting our leader, the president of the United States and his administration in dealing with this. And I'll talk about this a little bit more towards the end of my presentation. But let me say this as an introduction to the second part of my presentation, that is the human rights effects of the COVID-19 pandemic. The single largest human rights effect of the pandemic in this country has been the government's mismanagement of the pandemic, the federal government's mismanagement of the pandemic. It is without question increased the number of deaths in this country by probably 70 to 80,000 people. And there's no greater human rights violation than the death of individuals. So that has been, without question, the biggest human rights violation that has occurred, and it's been a result of our federal government. And I want to say that right up front. I'm going to go and talk about other human rights violations that have concerned me, and I don't want to diminish the ones I'm about to talk about, but the most important one has been the death of 70 to 80,000 people, if not more, needlessly because of the mismanagement by our federal government. So let me talk about the varieties of human rights concerns that I have during this pandemic. I'm going to break it into, let's see, 3 or 4 categories. The first is what is happening in our jails and prisons in the United States. The second is the privacy concerns relating to the efforts states and the federal government have made to try and manage the COVID-19 pandemic. And the third, the movement restrictions that have been in place by some governments, some state governments. And then fourth, the upcoming concern, well, the concern that's already happened in some people who work at the polls and who run the polls becoming sick with the coronavirus. And we've also had people, because there have been less polling places open, and the government has not allowed for mail-in voting, which has been lobbied for by many, that some states are opposed to mail-in voting. So we've had very few polling places, and we've had long lines of voters waiting for hours on end to vote, and those voters contracting the virus by virtue of that. So those four circumstances: voting, restrictions on movement, privacy, and jails and prisons. Those are the most apparent effects on human rights of this era of the coronavirus pandemic. So let me go back to jails and prisons. Let me use this analogy that some of you may be familiar with. If you all remember back in January and February, when there was first signs of this coming out of China and then Europe, there were cruise ships in Asia and off the coast of the United States that had individuals on the ships who tested positive for the COVID-19 virus. And very quickly, governments started not allowing these cruise ships to dock in their ports and to let people off the cruise ships, because they didn't want that as a mechanism to turn into a mechanism for the spread of the virus in their populations, in their ports, and in their countries. So what happened is there were these large cruise ships with 2,000 to 3,000 people on them that were a closed society, and it turns out most of the people on the cruise ships ended up getting the virus, and a not insignificant number of them dying, simply because they were in a closed environment where they couldn't get off, and there was no ability to eat or isolate themselves in a way that prevented them from getting the virus. I bring that example up because it has created the metaphor of a cruise ship environment. That is a closed environment where people are stuck there. They have no choice but to be there. And the virus makes its way through those environments. There are two examples of that in New Hampshire. The one I'm going to talk most about are jails and prisons. Those are what I would call cruise ship environments, where people are required to be there, and they have no way of leaving unless the courts or the jails release them. They are at the mercy of one person getting the virus in there, and it's spreading like wildfire throughout the jail or the prison. There are examples throughout the United States of that happening. For example, the pretrial jail facility in New York City called Rikers Island has had a huge outbreak of the virus because judges and courts and prosecutors have not been willing to release people from jail in anticipation of the spread of the virus in these cruise ship environments. And it's caused a spread like wildfire of the virus throughout jails like Rikers Island and other jails and prisons throughout the country. Some jails have been very, very good and cautious about protecting their inmates, trying to test them frequently, isolating those who tested positive, testing every incoming inmate for symptoms of the virus, and quarantining them for 14 days before they went into the general population. But across the country, the management of jails and prisons has been very spotty, and prisoners have been dying because judges have not been, even pretrial people who have not been found guilty of anything, pretrial prisoners have been dying because judges and prosecutors have not been willing to let them out on a home confinement basis. And that's of great concern. I personally have been working in the state I live in, New Hampshire, with the jails, which hold the less serious inmates and hold our pretrial population, to get them to agree to releasing on home confinement everyone who has not been found to be dangerous. And that has been reasonably successful. There's been the jail population, pretrial jail population in the state of New Hampshire has been cut by 2/3 from what it was 8 months ago, by virtue of the efforts I and others have made to manage that. But we've been lucky in New Hampshire. We have a relatively small population in the state. It's only 1.5 million people. And so the ability to do this work and form relationships with informal relationships with jailers, and talk to prosecutors on a personal level in order to get them to agree to this kind of release has been very successful. That has not been the norm around the country. So there are significant human rights violations in jails and prisons around the country. People who fit in vulnerable populations, elderly individuals, people over 60 in jail, people who have diabetes or heart conditions or high blood pressure, they're being held in jail and they're not being released even though they fit into vulnerable populations. Let me talk about privacy a bit. There are a number of ways in which privacy concerns are infringed upon. One that you see in countries like South Korea and Israel is what's called a high-tech version of contact tracing. The idea of contact tracing is that once you know somebody has tested positive for the virus, you want to go back and using their cell phone data acquired from their cell phone provider, you want to go back and see who they had, see where they were, and reach out to other people that you can tell were in that area based on their cell phone locational data, and try and reach out to them and call them up and let them know that they have been in contact with somebody. And going forward, once somebody is tested positive, if you want to track them and see if they leave their house and where they go, and inform those whose phones you have access to when they go to a place that this person has tested positive. Contact tracing of any kind, be it a low-tech version, that is talking to somebody who's tested positive and finding out where they've been in the last 2 weeks or 3 or 4 weeks, is a very valuable way to start to limit the spread of the virus. But there are privacy implications to that. The cell phone companies for whom are providing this data to the government, and this is happening to some extent in the United States, it's happening much more widespread basis in Israel and South Korea. The government has not gotten permission from the individuals to access their cell phone geolocation data. They've simply contracted with the cell phone providers to provide that information. And so that, to my thinking, is a privacy violation. They haven't gotten permission, and they're providing data to the government without permission. It is for a good cause, it seems, to protect the public health of the general public. And there is a good argument to be made that in the on the privacy of those individuals whose cell phone geolocation data was infringed upon was appropriate in the balance, that the public health concerns win out. But that privacy intrusion exists and is of concern. Another version of that privacy intrusion, involving more specifically healthcare data, is, let me give you an example. In the state of New Hampshire, the statewide public health department, they get of anyone who tested positive for the virus, then send out, and they get the address of that person, where that person lives in New Hampshire. They then send out notice to the local police department, the local fire department, and the local emergency medical technician that this person has the virus. They provide them with, those entities, the police, the fire, the EMTs, with medical information, the COVID-19 status of individuals in their community for public health purposes. So that if the fire department, the police, the EMTs come in contact with these people, they know what they're dealing with. So it seems to be a wise use of public health information, but nonetheless, it is a privacy invasion. It is allowed under our National Medical Records Protection Act, called HIPAA, HIPPA, the Health Insurance Portability and Protection Act. There's an exception there that allows that act normally protects one's medical records from being revealed to anyone. There's an exception there for this very circumstance. So it makes a lot of sense to do this, but there's a concern going forward with that I'll talk about. And there is an ongoing concern as to whether members of the police department and fire department and EMTs share that information with people who are not authorized to have access to that information, thereby stigmatizing people who have tested positive. That certainly was a concern back in the era of the height of the HIV/AIDS crisis in this country. It was a significant stigma to have tested positive for HIV/AIDS. And this circumstance I'm now describing risks creating that same kind of stigma. So those are the most immediate privacy concerns that come to mind. I'll come back to those in a minute. I'm just going to look at my notes for a second. Let me talk about movement restrictions. A number of states have said, if you come into our state from out of state, you must quarantine yourself for 14 days. You have to go to your location, and then you have to stay there and not go out for 14 days. Again, that's particularly true it was true in a state like New Hampshire, where we have a small population. The virus was not, there was not a high level of spread of the virus in New Hampshire, but there was a very high level of spread of the virus in the state of Massachusetts, which is on our southern border. And at a certain point, the state police put up roadblocks on our borders, stopping people with out-of-state license plates on their cars and telling them, you must quarantine yourself for 14 days before you start circulating in the population. And you are required to engage in the best social distancing practices, wearing a mask, staying 6 feet away. That was probably, again, notice the balance we're talking about, a restriction on people's movements, which has constitutional dimension to it, as does the intrusion on people's privacy. But by the same token, it was in a public health, for the good of the public health. And historically, courts have balanced, in public health crises, have balanced the public health concern against the restrictions on privacy. And I think, stopping people just with out-of-state license plates, just to tell them you must quarantine themselves is one thing. Prohibiting them from entering the state if they have an out-of-state license. Some states tried to do that. That did not work very well. It set up a really negative dynamic at the borders of, like, the state of Florida, for example, and that the significance of that restriction was too powerful. And finally, the states were limited to just asking people from out of state to quarantine themselves. But this continues. The state of New York has said, if you're coming from any of the current states, Florida, Texas, Arizona, California, that have this new surge of cases, you must quarantine yourself for 14 days. And that has restricted people flying from those states into particularly New York City. And businesses, particularly airlines and hotels, have complained very bitterly about the risk to their financial health going forward. And to the extent that airlines are not operating and hotels are not operating and restaurants are not operating, people are losing their jobs. And that, in its way, is a not insignificant human rights violation. Closing down a country or a state or a city in any significant way is a human rights violation for people of the nature of people losing their jobs. And that particularly impacts populations of color and poor populations. They're much more vulnerable to job loss, to lack of access to restaurants, lack of access to food, lack of access to money, lack of access to daycare. And the numbers around the United States are very clear. Populations of color are impacted 4 to 5 times more with coronavirus illnesses and deaths than the general population is. So the movement restriction, be it going to restaurants, going outside, traveling, has been a understandable and very important restriction to limit the spread of the virus to the extent it has done that. But in and of itself is a human rights violation. Finally, in terms of the human rights concerns that I have, is the voting concern. I talked a little bit about that at towards the beginning, where we've had several circumstances where, like in the state of Wisconsin, because of the virus, they didn't open very many polling locations. For example, in the city of Madison, Wisconsin, they usually had 15 to 16 polling locations, so that, you know, the population of Madison, Wisconsin who wanted to vote was not going to only one location. They closed all but 2 of those down because they didn't have the people to staff those polling locations and to receive the votes and to operate the apparatus to receive the votes. So they had lines that people were in line for 8 to 10 hours waiting to vote in the 2 polling locations in Wisconsin. And some of them received, were then later developed the coronavirus. The particular violation at play here is state of Wisconsin. Some in the Wisconsin legislature wanted to authorize mail-in voting in this circumstance, in that primary vote. What's called one version of it is called absentee voting, that you request of the clerk who runs the voting system that you be sent a ballot so that you can vote by mail, and you vote and you mail it back in. The Supreme Court of Wisconsin and then the U.S. Supreme Court denied the state the right to use that mechanism, that kind of mechanism, to deal with this voting crisis during the pandemic. So that, in that case, that's the courts and the government as a whole impinging on people's right to vote. It was one state. It did not seem, because people were so mad in Madison, Wisconsin, which is a notoriously liberal section of Wisconsin, which is otherwise a relatively conservative state. The liberal population of Madison, Wisconsin was so irate that the government was not allowing them to protect themselves, that they said, to use the heck with you all, the government, we're going to go vote and we're going to do so or not. And you heard quotes from people about that circumstance and their desire to vote. They would say, I am going to crawl on my knees over broken glass to go vote just to get back at you people. Now to transition to the longer term concerns with this very topic, the long term concern in terms of voting is the November election coming up. There's already, before the coronavirus happened, there's already been a lot of litigation and efforts. There's been a lot of efforts on the part of Republican-oriented organizations and states to put barriers to voting in place, to require that you show a photo ID for voting, which you never had to do before, that if you hadn't voted in 5 years, you had to re-register to vote. This was happening in a number of different states, all on the theory that they needed to prevent voter fraud. Of course, there's been no evidence at all, almost at all, of any voter fraud. There's certainly been no evidence of any pervasive voter fraud, people voting who shouldn't vote, people voting for other people voting in 2 different states. There's been no pervasive evidence of that whatsoever. Yet legislators continue to pass this kind of legislation, and courts keep upholding these restrictions. So that was occurring even before this the COVID-19 pandemic. Now the fight is over mail-in voting. We have several states, like the state of Oregon, has mail-in voting, has had mail-in voting for years. They've had automatic registration. When you get your driver's license, you're automatically registered to vote. There are other mechanisms for automatic registration and mail-in voting. The state of Nevada has had mail-in voting. They've had no voter fraud problems whatsoever. It turns out there's been no particular evidence that those states that have mail-in voting have seen an increase in Democrats voting versus Republicans voting. In fact, in many of those states, it's been a great mail-in voting has been of great value to elderly populations who find it difficult to get to the polls. It tends to be the case nationally that elderly populations, until the Trump administration and recently, elderly populations had voted Republican, more Republican than Democrat. So it's a very complicated political mess, but the concern for November is that the games are going to be played with the number of polling places that are open, the disallowance of mail-in voting, very tight restrictions on absentee voting, all quote unquote in the name of the coronavirus, but actually in direct opposition to facilitating people voting in the midst of the coronavirus. So that is, putting aside death and torture and loss of freedom, the denial of the right to vote is as significant a human rights violation as can occur, and it seems to be leading to a potential very significant problem in November. Finally, let me talk about the privacy restrictions and my overarching concern with that which has been happening with privacy efforts. My concern is something that I would call mission creep. That is, you say, oh, we're just going to do this for this very limited purpose and for this very limited time. We're going to intrude on your privacy for this very limited purpose and for a very limited time because it's really important for public health. And then when the public health crisis abates, the intrusions continue. They don't go away. The classic example of that was back in the 1940s when the Social Security system started in New Hampshire, and the Social Security Administration started, and they assigned everybody there was legislation to assign everybody a Social Security number. And there was this huge debate in the federal Congress about the dangers of everybody having a universal identification number. And that could be used to intrude on their privacy if it were used as such, as a universal identification number. And those in the government said, oh, no, 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 we just are using it for this very, very limited purpose so that people contribute to their Social Security account as they're working. And then when they retire, they have money that the government has saved for them and contributed to also for their retirement. It's a safety net for elderly people when they retire. They said that's the only purpose for it. We're not going to go use it for any other purpose than that. Fast forward to 80, 75 years later, and your Social Security number in the United States is effectively your universal identification number. The concerns that people had expressed back in the 1940s when it first came into being have turned out to be the case. Once it became useful, it just started getting used to more and more. So let's update that. What is going to happen to all these cell phone geolocation data that the federal and state governments are gathering on people and their movements around the country and within the state? as the virus abates and as we go back to whatever will be our new normal after the end of the virus. That data is going to still be accessible, number one. Number two, is the government going to stop accessing that data? Or are they just, well, we had access to it before, we can imagine it will be useful for other reasons and other things, so we're going to continue to get access to this and we're not going to tell people we're accessing their cell phone data? That's a very, very significant concern of mine in terms of what I call high-tech privacy. That it just facilitates something that is already a problem in this country and across the world, which is access to personal data via smartphones, via cell phones, via computers. And we are breaking down more and more boundaries in an effort to stop the spread of the COVID-19 virus. But by doing so, we are acclimating people to having less and less privacy, all right now in the interest of very significant public health concerns, but that's not going to be the case going forward. So that debate is raging in the United States. I think it's happening around the world. It's the most significant privacy concern with the COVID-19 pandemic, and is by its nature a human rights violation. As I said earlier to the hosts of this event, I could go on forever talking about this, but I'm going to try and limit myself. So I really appreciated you all listening to me, and I am very I very much welcome questions from you that will be sent to me, and I'd love to answer your questions and continue this conversation. So thank you very much.
Thank you so much, sir. Thank you for giving a comprehensive account of variety of human rights violations taking place, and also on reflecting on human rights that are not violated yet but are in a highly susceptible state. Further, you also highlighted certain solutions that can be looked into in order to save millions from the ruined state with which they are currently suffering. Moving further towards our next speaker, who is Advocate Amit Anand Tiwari, Advocate on Record, Supreme Court of India. Advocate Tiwari completed his LLB and LLM degree from Faculty of Law, Delhi University. He cracked his examination of Advocate on Record in the year 2017, but has been practicing before the Supreme Court of India since 2001. He has been a special counsel of CBI Enforcement Directorate. He has also acted as a Deputy Advocate General for the state of Uttarakhand for the period of 2 years. So also acted as a special counsel in several sensitive matters of CBI, Airport Authority of India, and Ministry of Urban and Rural Development. Advocate Tiwari also has a good experience in international commercial arbitration. With this vast exposure in the field of litigation, I would invite Advocate Amit Anand Tiwari to please discuss on the ambit of public interest litigation in COVID-19, which is very much used as a tool for the advancement of the social justice. Thank you. Please, sir, we invite you.
Very good evening and hello everyone. I am thankful to the Faculty of Law BHU for this opportunity to speak on the topic PIL as an instrument to check the misuse of power by the executive during the COVID-19 periods. So before speaking on this topic, I will divide my speech in 5 headings. That firstly, what is PIL? Then secondly, why we Constitutional Court need to use this tool to act balancing the powers of the authorities. Then third would be how courts have used this tool in the earlier times. Then how this tool can be used in the current scenario. My last point would be the limitation and flaws of use of this tool. So coming to the first topic, first head of this topic, what is PIL? Actually, if we see in the traditional sense, any dispute which is to be adjudicated between the parties, a party must be aggrieved one. like someone has taken over property of another person, the courts will intervene. He will approach the court, he will agitate the issue that my property is taken over, and in those cases the court will intervene and pass. Or similarly, some offense has been committed, a person has committed some offense, the state will intervene or the victim will approach the court and get an order. This traditional sense of locus or dispute was felt to be inadequate, and in America a special tool which was named as social interest litigation, where the public spirited person approached the court for causes and issues where larger public interests are involved. It was not those people have any individual or personal interest in the matter. They may have or may not have, but in the larger public interest they approach the court for seeking redressal of such issues. From late 70s and early 80s, this tool was utilized by Indian courts also, the Supreme Court of India to be more specific, and these petitions were named as public interest litigation, where a public spirited person approaches the court by seeking some direction, some orders from the court relating to those people of the society who are poor, who are ignorant, or who are not in a position to approach the court seeking redressal of their grievances. So, public interest litigation in that sense is a petition by which an individual or a non-governmental organization or a citizen group seek intervention of the constitutional court on an issue that has a larger public interest. This has been achieved by liberalizing and relaxing the rule of standing and locus, by allowing any person, association, or organization acting bona fide and pro bono publico to approach court in a larger public interest. In this backdrop, I would like to read a passage from People's Union Democratic Rights versus Union of India, one of the earlier judgments on PIL, which was decided in 1982 by the Honorable Supreme Court. The court noted that traditional view of standing will result in closing the doors of justice to the poor, deprived, and illiterate section of the community. And it was necessary to evolve a new strategy by relaxing rules so that justice may become easily available to lowly and lost. And the judicial system is evolved into an instrument of socio-economic change. It was further held in that judgment that PIL is a cooperative or collaborative effort on the part of the petitioner, state, and the public authorities, and the court has to secure observance of constitutional or legal rights, benefits, and privileges conferred upon the vulnerable section of the community and to reach social justice to them. But this brings us to another aspect of the public interest litigation, that is public interest litigation is similar to something like class action suit. In my opinion, they are different, because in a class action suit where a class of people having some injury by some action of the government or by executive join together and approach the court. In public interest litigation, in fact, the person approaching the court may not have any interest at all. Like the Bandhua Mukti Morcha case, there the petitioner had absolutely no locus in the matter. They approached the court on behalf of those who had the laborers who were not being paid adequate wages during the Asiad Games times. Similarly, Mathura rape case, where two of the renowned faculty member of Delhi University, Professor Upendra Bakshi and Lolita Sarkar, approached Supreme Court and agitated the issue about the rape victims, and ultimately which led to a large number of directions and change in rape law. Initially, PIL was sought to be seen as a cause brought before the court by a public spirited person who is furthering some social cause in which a section of society, especially some disabled, weak, or illiterate section of society, may be interested, but who cannot, because of their ignorance or poverty, approach for redressal of their grievance, like Badua Mukti Morcha case, Hussain Ara Khatun, a large number of under trial prisoners were released by various directions in Hussain Ara Khatun. However, with passage of time, this tool of PIL has now been used not only for taking up the causes of poor and downtrodden, or those who cannot come up and agitate their issues before the court, but also by those for observance of the constitution, constitutional values, preservation of rule of law, like the judgment of PUCL in 2004, which relating to election reform cases, like recent public interest foundation judgment, where the various directions were passed for disclosing the criminal antecedent of the those public servants, those leaders who wants to contest any election. In fact, recently a direction has been passed by the Supreme Court, in which it has directed all political parties to see that to record reasons for saying why they are choosing a particular candidate who is having any criminal antecedent. So therefore, with the passage of time, this PIL tool has not remained the confined to those traditional cases of approaching the court for poor and downtrodden, but courts have in fact acted upon the PILs which related to like 2G and coal cases, which by which they ensured that preservation of rule of law is done, by which constitutional values are upheld, by which basic structure is not somehow compromised. So a PIL, to summarize, a PIL is a tool by which any public spirited person, not having any interest in the subject matter, but general interest in general public welfare or larger public interest, can approach the court and ask the court to intervene on subject matter. Then the second issue which we will be discussing is why ultimately Constitutional Court needs to intervene in by way of these tool of PIL. So constitutional courts, we have seen, like every one of us know, that PILs are not filed before any district judge. You come to only a high court or Supreme Court seeking PIL. These constitutional courts, firstly, they have a constitutional duty to preserve the constitutional values, the equitable causes under the law, and to preserve the overall basic structure of the constitution, which is not available to district courts, and therefore PIL are not filed before the district courts. So constitutional courts are under a constitutional duty to check the misuse or abuse of power by legislative and executive. So therefore it is important that they perform these tasks, and PIL becomes a very important and very critical tool in performing this duty. About Constitutional Court, there is a book by Aaron Barak, who was a former Chief Justice of Supreme Court of Israel. He has written a very powerful book on the role of judges in the democracy. The book title is The Judge in a Democracy, and where he beautifully explains the role of the constitutional courts and the judges. According to him, judges in traditional sense, they are constitutional court judges not only resolve the dispute, inter-party dispute like traditional courts, but they also have duty to bridge the gap between law and society, and they have to protect the constitution and democracy. I'll quote, he writes in his book that the in order to bridge the gap between law and society, the courts and the judges needs to adapt and interpret the law in a manner which will complement periodical social changes. Secondly, the courts and judges are under a duty to protect constitution and democracy, since the judges are ultimately accountable not to public opinion or to politicians but to the internal morality of democracy. And we can take it further that not only to internal morality of democracy, but in India, since we have evolved the concept of basic structure of constitution, the judges are also morally responsible. They are bound by law to ensure that basic structure of law remain in place, basic structure of constitution remain in place. And for these to remain in place, it needs someone approaching the court and agitating the issues. So, public interest litigation in that sense provide a wider reach. And to tell you very frankly, since these public interest litigation, since the party approaching the court does not have any personal interest, in that sense, the argument becomes more theoretical or academic. And to look from that perspective, if we look that what it does when you have a theoretical and kind of academic discussion, it results in broader interpretation of various law, right to equality, right to life, right to personal liberty. Like in DK Basu case, when entertaining public interest litigation, the Supreme Court interpreted right to life under Article 21 and read with Article 20 various rights of an accused. It said that the moment a person is arrested, his near dear ones must be informed. He must be given access to legal advice. He must permitted to make a phone call to his family members, and plethora of other directions were issued, like not torturing him and other things. Similarly, if we see this Vishaka case, where right to life was expanded and it was interpreted in a manner where court ultimately found that it is an essential concomitant that when a woman goes out and work in that workplace is such made so secure that she can comfortably discharge her day-to-day official duties and function. And lot many directions were issued. So it can be seen that therefore PIL plays a very important role in allowing the judges to fulfill their constitutional obligation, moral obligations, because ultimately judges are the protector of fundamental right of the citizen. They are the arbiter between the powers of the executive and legislative on one hand and the citizen on the other hand. So therefore constitutional courts should utilize and have been utilizing the tool of PIL to further the constitutional obligation fastened on them. This brings us to the next topic, that how the courts have used PIL in earlier times. So, as I cited certain example, the earlier the first set of PILs were relating to under trial prisoners in Hossainara Khatun, and the rights of the laborers working in Asiad village cases. Thereafter, the tool of PIL was also very effectively used to ensure the independence of judiciary by interpreting the provisions of the Constitution in SP Gupta case and Iskora case and Supreme Court Bar Association case on a later occasion. So, therefore, in earlier times, it appears that initial days definitely the court was confined more to the individual rights and of downtrodden poor. But subsequently, it went on to interpret the provision of law in a manner which rather further the cause of the constitutional mandate and the basic structures of the constitution and overall democratic setup of the country. Uh, now, now if we see in the we come to the topic, the main issue which I was supposed to discuss was the in present COVID times. um, there are situation, numerous directions are being issued by the government uh, under NDMA Act and the Epidemic Act of 1897, and various by which the freedom of movement, right to personal liberty has been curtailed. Freedom of movement has been curtailed in the sense that by putting a lockdown, the people were prevented from moving from one place to other, and the personal liberty was curtailed in the sense that those who are being found affected by corona, they are mandatorily are required to be quarantined in the sense they are required to remain in isolation in one room. They cannot come out, so therefore right to liberty is curtailed. Then right to trade and commerce has been curtailed in that sense, because the lockdown has completely brought a halt to the economic activities. Shops have been shut down, curfews have been imposed. Not only this, in fact, there is one more serious aspect, is the right to privacy. The government now mandates that every person must download this Arogya Setu app, and this Arogya Setu app must be on a Bluetooth on mod, which in fact tracks the movement of the person, what he does, in whose contact that person comes. All these data goes back and is stored in the government server. And to tell you, there are 10 security agencies which even otherwise have been monitoring the data. So this data is being utilized to monitor the movement of person if he is COVID infected. Uh, I have one of my neighbor who contracted corona. Um, he was asked to download this app, and one day a police personnel visited his house and said that you are making movement outside your house. If you go out again, there will be a FIR registered. This shows that app has been monitoring the movement of the person, and as this person was moving out, even police was monitoring such person, and they came visited the place. So therefore, in that sense, there are serious consequences. While it is true that the time is also very serious, this never before kind of a situation has taken place, where the situation is such that no one knows what this pandemic is, how to treat the person suffering from this virus. And the contagious effect of this virus definitely has had impact on psychological, financial, physical, and all other aspects of a human personality. Uh, I have tried to summarize certain examples of use of PIL in current scenario. These examples can be seen that in recently the fundamental right of privacy, Arogya Setu is one. The right to healthcare worker, they are not being given adequate safety gear. The rights of migrant laborers who wanted to go but they were not able to go because there was a complete lockdown. Even all transports were closed, so they were walking on their feet. Now when they were walking, trying to cross borders, the police were committing atrocities, the authorities were committing atrocities. Similarly, the testing facility, not by not providing adequate testing facility, in fact the um, in one sense Article 21 of life and liberty is being compromised by the state. The action of the state government to various state government to shut borders have also caused a lot of fundamental right related issues, like cross border movements. So these were certain example on which in recent time the people have approached court. I'll give those examples. I have called out those examples, and I'll give the names of the cases. Like in Shashank Dev Sahi versus Union of India, in a recent case, the Supreme Court was approached by in a public interest for issuing of direction for ensuring providing free of cost testing facility of COVID-19 by all testing lab, both private and government. The Supreme Court intervened in this matter and directed that tests relating to COVID-19, whether in approved government laboratories or private laboratories, shall be free of cost. Then, in case of OP Gupta, another PIL was filed for issuing appropriate direction to Union of India and the state of Haryana to allow movement of people between Haryana and Delhi, because Delhi and Haryana border was closed and people were facing problem. While they were allowing people to enter from Haryana to Delhi, but people going from Delhi were not allowed to enter unless until they had a proper pass on their person. So the court took this PIL and passed an order directing the state of Haryana to allow smooth movement. Similarly, when there was a PIL filed when the similar problem was created by Noida and Delhi. So there also the court took note and on undertaking of the authorities that they will facilitate the smooth passage. The court, by recording those submissions, disposed of the matter. In Gerald Bennett versus Union of India on a public interest litigation by a medical professional seeking appropriate direction to central and state government to provide the doctors and other medical staff with PPE kit, gloves, starch apparel, etc. The court proceeded to issue a large number of directions for providing a proper facility and availability of kits, gloves, and other things. Similarly, in one more the PIL was filed, which was relating to migrant worker, and Supreme Court issued number of direction to central government and state government that there should not be any collection of fare from the workers either for train or bus journey. It was directed to be provided free food and water by the concerned state, union territory. The migrant workers were also provided meal and water for their on road journey. So these are few examples by which the court has been proactive while protecting the rights of individual and larger and orders were passed in larger public interest. However, if we see that these PIL, because the times are such that at this point of time no one is questioning the excessive executive authority being utilized by the government, but they also would be subjected. I feel that there would be challenges, like challenge was made to use of PM Care Fund and all those things, and these challenges will also come up soon. As I visualize in my experience, the people, public spirited people, will also like to challenge the non-democratic functioning wherever they feel that functioning is non-democratic, or to ensure that constitutional principle and democratic principles are upheld. Now this brings us to the last issue on this topic, which according to me are equally important to understand in the setup when we discuss about the PILs, is the limitation and the flaws in use of PIL. Theoretically, the public interest litigation permits the people who are public spirited, public oriented to approach court, and so that they can agitate grievances of the in larger public interest. But it has been realized that these public interest litigation sometimes have been used as personal interest litigation also, and courts have been flooded with a large number of PILs on all and sundry issues. It should be noted while these PILs are utilized to ensure that functioning of the legislature and executive are in place. It does not seek to replace the functioning of legislature and state by the functioning of another authority, that is court. Further, while legislature and executive authority have lot many technical assistance and input, these PILs are basically discussed and argued in a very limited aspect, where the firstly judges are not expert on the subject matters, most of the subject matters. Secondly, the persons who are presenting the case, mostly the lawyers, are also not the subject expert, domain expert, which results in somewhat the limited understanding of the subject, and sometimes the court tends to encroach upon the executive domain and policy domain. Therefore, while utilizing the tool of PIL, which is very essential for upholding the public and the constitutional values, larger public interest and constitutional values, it is important to understand these limitations. And I hope and wish that uh, the executive and government and the legislature must act in such a manner that the use of this tool is lessened as much as possible, to restrict to only constitutional issues, and not for mundane not for public interest like the COVID times, where I hope and trust the government should function in much better manner without requiring us to approach court by way of these PILs. So with this, I'll finish my speech, and thanks once again to everyone.
Thank you, sir. Thank you for making us aware about the various public interest litigations filed in past few months and reliefs granted on those, reflecting the proactive contribution by the Indian judiciary. Moving towards our next speaker, who is Dr. Sergei V. Nestrov, who is a professor of medicine at University of Turku, Finland. Dr. Sergei completed his doctorate in medicine from St. Petersburg State University and PhD from Russian Academy of Sciences. He has also completed postgraduate certificate project in project management and business administration from University of Wales. He has been a grant holder in many projects and holds high quality publications in international journal. I request Dr. Sergei to please give us an overview of the medical scenario during COVID-19 in Russia as well as in Finland. Please, sir, we request you. Thank you.
Okay, hello everyone. It's Sergei Nestorov from Finland, and I will tell a few words about coronavirus disease in Finland, a few words in Russia, and in general, also a few words. So actually, as all you know, we are currently living, today is the 5th of July, and we are living during this coronavirus pandemic, and it's the really dramatic thing that we're living in during this half year of 2020. Although this virus is called COVID-19, as it was first identified in 2019, actually in Wuhan and province Hubei in China. So it's primarily spread between people and during the close contact through small droplets that are produced by coughing, sneezing, or talking. It's pretty resistant, and it can survive for 10 minutes. In air. But actually, if you are good with your hygiene and you wash your hands and you keep the distance, it's okay. You can protect yourself. The distance that is recommended is from 1 meter to 2 meters. There are different recommendations. So if you keep 2 meters, that will be really fantastic and great, and you will not get disease if somebody is 2 meters from you. Also, wearing a mask actually helps and as far as I know, actually, it can be any mask. It can be any mask, and you can even wash it yourself, dry it, and then reuse it again. So masks are good. What makes this virus pretty problematic is that it affects lungs, as well as other organs as heart and kidney, but mostly lungs, and you can develop really bad syndromes with your lungs and you can die. So, okay, these are general things, and the more, if you're interested about the medical and biological, virological part, you can check in basically lots of outlets in internet. About Finland. So currently, for today, for the 4th of July, for the 5th of July, we have 7,242 cases in Finland and 329 deaths. 20 people are currently in hospitals. They stay in hospitals, and nobody is intensive care any longer. So the situation is normalized, it's pretty good. Concerning Russia, currently, according to official data, there are 680,000, a bit more, sick people. And yesterday, actually on Saturday, 4th of July, there were 6,736 new cases. So basically, only yesterday, there are as many sick people in Russia found, diagnosed as sick people, as there have been during this half year in all Finland. One day, all Finland. And in Russia also 10,161 persons died from this coronavirus. These are official data. As for the situation, I can better tell about the Finland. So on the 13th of March, it was Friday, all gyms were closed and all swimming pools were closed. And on the 16th, it was told that actually all schools will be closed. And if I remember correctly, from the 18th of March, schools were closed till mid-May. So for 2 months they were closed. And children were studying at home. Also, lots of workplaces were closed. The places of the restaurants were closed. University was closed and people were staying at home. Frankly, I think that the homeschooling using all this Zoom, WhatsApp, Viber, Google Docs, okay, it's better than nothing, but of course it cannot substitute for the proper schooling with a teacher. So definitely it's some compromise. Of course, it's good that we have these tools now and we can do it somehow, but hopefully everybody returns to the normal situation soon. So for 2 months, as I said, everything was closed. Schools were closed, and from mid-May, I think on the 15th of May, schools were open, and they, for 2 weeks, they were going to schools with all these measures of precaution, washing hands, like the line between people was, like the distance was at least 1.5 meters. In Russia, actually, the situation is a bit different because, according to official data, the number of sick people is decreasing, but still lots of people stay at home and they do not go too much and mingle too much. Frankly, I don't actually understand what I do not know what to tell more. Only just that I hope that everything will return to the normal functioning as soon as possible. And if my own opinion, I think that the measures that, for instance, Finland, it's hard for me to speak for Russia because I'm not living there now. But for Finland, I know that some people think differently, but I think that the measures that were taken by government, they were pretty adequate, and thanks to the medical specialists, I think they were really. I have some friends who were working, and they were working really long shifts, and they really had all these signs on the face after these respirators. They did great job, and it's good. It's good what they did, and hopefully we will have vaccine as soon as possible. Although unlikely it will happen before autumn. Also, I hope that there will be no second wave, or third wave, or fourth wave, which unfortunately is likely. But otherwise, it was a very challenging time, and I hope that we go out of this soon, and maybe having learned some new things. Thank you.
Thank you, sir. Thank you so much. Moving further towards the last speaker of the day, who is Dr. Sheetal Kumar Setia. Dr. Sheetal Kumar Setia is currently an assistant professor, Faculty of Law at University of Mumbai. Dr. Sheetal completed his LLB and LLM from Department of Laws, Punjab University, Chandigarh. Sir also served at Army Institute of Law, Mohali for the period of 6 years, and Sir was an external examiner of curricular moot court activities and seminars at Rajiv Gandhi National Law University. Dr. Sheetal participated and made many presentations in national and international seminars on variety of legal issues. He has been teaching law and social transformation, human rights, information technology, and insurance laws to postgraduate students at University of Mumbai. With these words, I request Dr. Sheetal to please address the legal issues related to the migrant workers. Please, sir, we request you. Thank you.
Greetings, everyone. I feel privileged here to be a part of the international webinar on human rights issues amidst COVID-19, challenges and solutions. Right at the onset, I'd like to thank the organizers for having invited me and asking me to be a part of this program. My talk today is going to be about guest workers or migrant workers. Well, when we talk about migrant workers, there can be many contexts. There are those migrant workers who go beyond the country's borders into other countries and offer their services there. We see that happening in Indian workers going to the Gulf, serving there, workers from the CIS states going to Russia, offering their services there. And this has been going on for a very long period of time. We have had Turkish workers in Germany in the past, but a bigger number in countries like India is of those workers who travel within the country from one place to another and serve at the other place. We see big movements of people within the country in India because investments in a country may be in one part of the country where there might be other resources, but human resources may be derived from a different place. In case of India, as per the World Economic Forum, it is estimated that there are 139 million migrant workers. Now, they primarily come from 4 states, from Uttar Pradesh, from Bihar, from Rajasthan, and from Madhya Pradesh. And the biggest recipients in terms of cities of these workers are Mumbai and Delhi, whereas in other states, in other parts of Maharashtra in particular, and in Gujarat, also there are quite a few migrant workers. So migrant workers travel from one state to another. They are in most states, but the larger numbers tend to come from these states or go into these states, as I just mentioned. Now, in case of India, 80% of the workforce is in informal sector. As the COVID-19 outbreak happened, well, that led to a lockdown and the closure of many industries. This led to many of these workers being rendered jobless. Now, these workers being jobless, their wages being restricted, their wages not being available to them, led to difficulty in carrying on with their lives. Now, many of them decided to move from the places they were at to the places where they were from. But lockdown meant that they were not supposed to do so. Interstate movement, inter-district movement, and sometimes immediate movement. So even immediate movement was restricted. And that, it was felt, was important for the sake of keeping a check on COVID-19 as it was understood then. In Maharashtra, it is estimated that there are 38 lakh migrant workers, out of which it is estimated that 12 lakh had left for their native places. Now, since there was no regular or ordinary way to travel from one place to the other, neither in the form of trains nor buses nor any other form of transport, the movement was primarily on foot. And this movement was a movement which the state did not want at that point. Now, this led to challenges to many of the human rights of these workers. Their rights, it's not just that these rights came under challenge only while they were walking, only while they were traveling. The reason why they traveled, the reason why they wanted to leave the places they were working at and going to their native places was that many of those rights were not available at the place where they were at. As various states declared a lockdown, this led to the closure of many businesses, many industries, as well as other establishments. It led to a huge loss of jobs. We see migrant workers working in various fields, various different sectors of the economy. We see them working in factories, we see them working as in the transport sector. If we look at those driving our taxis, those driving our auto rickshaws. We also see them working in the food sector, in the hospitality sector, and various other sectors where migrant workers are an important part of the workforce. So as these businesses shut down or as these businesses closed down for owing to the lockdown, many of these workers lost their jobs. And since most of them were in the informal sector, it made them very, very vulnerable. What that did was, these people did not have access to any money thereafter. This led to not even basic food and essentials being available to them. This led to starvation, as well as a difficulty for retaining a roof over their heads. The rent payments were pending, the food had to be arranged, the income was limited or restricted or zero. So in such situations, they had no option but to go back to their native places where they felt that they had access to at least a roof over their head, at least basic food and other essentials. Since the borders were closed, since movement was restricted, this movement was a very treacherous one. The journey was painful. One, it was illegal. Since many states had declared curfews like Punjab, any movement at all became difficult. Whereas in other places, the lockdown was pretty strict. Movement from one locality to the next, from one district to the next, was very, very tough. And going from one state to another was nearly impossible. Since many of these workers had come from far off places, they had to go to those places violating all these rules and regulations. In addition to that, the difficulty was that facilities for transport were also not available. There were no buses, there were no trains to begin. So in the beginning, the movement was primarily on foot. This was a movement that was being discouraged by the state, a state which was deeply concerned about the movement of the virus from one place to another along with the people. So this treacherous journey in very warm weather led to many difficulties. Many of these people suffered from dehydration, exhaustion, stress, and this led to many of them even attempting suicides. This long movement also led to many accidents. Many lives were lost. Accidentally, trains ran over many of them. Many of them tried to board the trucks which were carrying essential supplies. Many of those vehicles also suffered accidents. So many people lost their lives not just due to exhaustion, not just being subjected to the elements, but owing to road accidents as well. So the number of deaths actually ran into hundreds, it is estimated. On reaching their native places, they were treated with bias because those living at those places feared that these people who were coming from the bigger cities, they were carrying the virus with them. So it meant that many of them had to spend time out in the open, staying in the fields overnight, or spending time inside rooms which were basically meant to be storehouses or which were meant to be shelter for pump sets which were there for irrigation. Other than that, there was a sense of public shaming and people were not ready to interact with them, basically. These deaths and this long migration, that movement that happened in the wake of COVID-19, led the UN High Commissioner for Human Rights, Michelle Bachelet, to say that she was distressed by the plight of migrant workers in the wake of the lockdown. And she asked India that it should not exacerbate existing inequalities and vulnerabilities of these people. This treacherous journey, which saw lots of accidents and lots of other difficulties on the way, also injured their dignity. Throughout the way, they did not have access to sanitation facilities. Now, sanitation facilities were anyway limited in areas where they were living, in the bigger cities. But once they were on the move, access to sanitation facilities became all the more difficult. The sanitation facilities along the road at various petrol pumps, etc., also became unavailable as people were concerned about the use of public toilets and those places being leading to the spread of the virus. The use of those places leading to the spread of the virus. As and when movement across borders was allowed to them, they were subjected to being sprayed with disinfectants. But that also can be seen as one way in which their dignity being injured, since they were treated as if they were goods. And just as goods are sprayed with disinfectants on crossing borders, the same was done with human beings. Now, what was the state's response to this? The state in the beginning, in its concern that the virus should not move from one area to the next, tried to restrict the movement of people. But over a period of time, they realized that these restrictions are not sustainable and people are really keen to move on from one place to their native places. So what the state did was they allowed this movement eventually. But by that time, many lives had already been lost. Yes, buses were arranged, but they were woefully inadequate for the needs of that time. Thereafter, Shramik special trains were introduced. which, yes, eventually did carry people from one place to another. But at the same time, these trains also lacked facilities in the beginning. In fact, these train journeys were very long, and on the way, those traveling by those trains did not have access to food or water, which led to many of them being subjected to a lot of difficulty. Thereafter, the state tried to arrange for food and running community kitchens. In fact, in our own university, a community kitchen was being run by some of the faculty members in association with the state. The food facilities, well, again, were not adequate enough, and many of them were left starved. The state tried to implement many new plans. Some of those plans were already underway, but awareness regarding availability of rations was not there. One ration card, which can be used all over the country, is a scheme that was already under implementation. Many of these workers who carried ration cards from a different state but were present in a different state had the right to receive rations in the state where they were in. But many of them did not know that they had this right. So they could not utilize the same. Plus, this scheme has not been implemented throughout the country as yet. Other than that, many other measures were taken by the state. They developed a new national migrant information system. Now, in spite of having laws in the past, a proper database of workers as to where they were from, what skill sets they had, where they were working, such information was not collated and was not available in a proper manner. So this information system was introduced. Other than that, many measures such as Garib Kalyan, Rozgar Abhiyan, etc. were also introduced. Some states acted more innovatively. What they felt was that they have the workers who have the experience of working in various industries. The states where they came from, or their native states, were the states which were less industrially developed. If you look at Uttar Pradesh, Bihar, Rajasthan or Madhya Pradesh, the degree of industrialization is not quite as much as we see in Maharashtra or Gujarat or Tamil Nadu, for example. So Uttar Pradesh followed by Madhya Pradesh, what they tried to do was they tried to revise labor laws, using that as a means to attract more investment by industries. But that is something that is in the nature of a long-term measure, and the injury to the human rights of migrant workers is something that cannot be, in immediate terms, stopped by such measures. What are the solutions available to us in these circumstances? The solutions are not immediate or complete, but at least an attempt can be made. In some states, orders were given that these workers be paid their wages by their employers, uncut and unrestricted. But the employers themselves were in a difficulty. So many of these states who gave such orders later withdrew them as well. Yes, the states also tried to ensure in some places that the landlords are not, or the landlords do not require them to pay rent, at least for the period during which the lockdown was operating. But these measures have proved to be woefully inadequate to deal with the difficulties which these migrant workers have faced in the wake of the pandemic. What are the solutions at hand before us? Although we cannot say conclusively as of now as to what the best solutions for the same would be, as the situation changes, as the situation evolves further, new solutions might emerge. But as of now, the basic steps that ought to be taken is that with the skill sets of the workers being mapped and these workers having come to their native states, the states should ensure that these workers who are experienced in working in various industries be gainfully employed in their native states themselves. By attracting investment in those places or with the state pitching in with investments or at least providing infrastructure for investment. Should these workers decide to return to the places where they worked earlier, in those places also it is important that measures are taken that their jobs are not lost due to the rise in subnationalism or ethnocentric tendencies. And workers from all places are employed back in the places where they have worked with open arms. They are welcomed back with open arms. With these words, I'd like to thank the organizers for having invited me to participate in this program, particularly Dr. Gurvinder Singh and all members of the faculty here at Banaras Hindu University. Thank you so very much for having me here.
Thank you, sir. Thank you so much for elucidating the gross human rights violations that labour class had to face at every step of their struggle to fight with the coronavirus pandemic. This reminds me of the quote by King Martin Luther, which is, to quote, "No work is insignificant. All labour that uplifts humanity has dignity and importance and should be undertaken with the painstaking excellence," unquote. As I reflect on this quote, it tells us how to respect and honor the work no matter what the job is. And definitely to respect and honor the one who is doing or performing that particular job. Even if they are labor class, they are entitled to the human rights no less than any other community, no less than any other individual. But what is being seen these days is something which is totally contrary to the statement. Anyways, moving further, at this point of time, it is extremely important to focus on the measures that can be taken to safeguard the human rights violations. There is need for taking human rights into account in implementation of the protective as well as mitigating measures adopted by executive in response to fight with the coronavirus pandemic. Keeping in view the entire scenario, our speakers, along with highlighting the challenges, have also provided us with certain holistic solutions that may prove out to be fruitful in overcoming the tussle in shielding or saving the human rights. With these words and moving towards the end of this international webinar, I request Professor D.K. Mishra, Faculty of Law, Banaras Hindu University, as well as the Joint Director of this international webinar, to kindly wind up and summarize with the webinar and please give a formal vote of thanks. Please, sir, we request you. Thank you.
Good evening to one and all. Respected dignitaries, learned colleagues, dear participants, students, friends, ladies and gentlemen. I have been directed by the organizers to propose a formal vote of thanks. Friends, I am sure you have enjoyed such an insightful, thought-provoking and informative deliberation in today's international webinar on the contemporary and relevant theme, Human Rights Derogation amid COVID-19. Now, I take this opportunity to acknowledge the contribution of those who have shared their views as speakers. First of all, I respectfully express my gratitude to our Honorable Vice Chancellor for giving his kind blessings and encouraging us to organize this international webinar. It is remarkable that despite hectic schedule in the university, he has always made himself available for the academic activities of the law faculty. Thank you very much, sir. Professor R.P. Rai, Head and Dean, Faculty of Law, has always been a source of motivation and guidance to all of us. When the members of organizing committee approached him and proposed this idea to organize this webinar, he not only permitted us but keenly took interest at every stage which made this event successful. Thank you, sir, for your kind cooperation. I, on behalf of the Law School, Banaras Hindu University, and on my own behalf, extend our sincere and profound thanks to all the speakers, both from India and abroad. Especially in this line, I thank Professor Albert for delivering keynote address, who has spared time despite his busy academic schedule and agreed to share his thoughts. Professor Albert lucidly explained the situation of COVID-19 in the United States and acquainted us with the human rights scenario during this pandemic. Thank you, sir. I also express my gratitude to Dr. Sergi from University of Turku, Finland, for his valuable inputs regarding the health and mental condition during the pandemic. Thank you, Dr. Sergi. On behalf of the Faculty of Law, Banaras Hindu University, I express my heartfelt gratitude to Sri Amit Anand Tiwari, Advocate, Supreme Court of India, who spared his precious time for this academic discourse. Today, we had the opportunity to hear your views on public interest litigation and its relevance during this pandemic, when many of us feel that extra authority applied by the government has breached the constitutional limits. Your views certainly have enriched the participants and students both. Thank you, Dr. Tiwari. I am thankful to Dr. Seetal Setia from University of Mumbai, who has shared his views on the plight of guest workers during the COVID-19 period. Your critical appraisal about the government policies for handling the labors and the related issues was eye-opening to us. Thank you very much, Dr. Setia. Now, I am thankful to my learned colleagues, scholars, researchers, and my dear students for listening the idea and the views of the speaker patiently. Last but not the least, I acknowledge the collective effort made by the team members of Organizing Committee, Faculty of Law, BHU, and therefore express my sincere appreciation for the teamwork they have displayed. Thank you to all. Jai Hind.